Hello, everyone, and thank you for joining us today for the first of our second series of Alberta SPOR Knowledge Translation webinar series. My name is Denise Thompson. I'm the Associate Director for the Alberta SPOR Knowledge Translation Platform, and I'm delighted to welcome you all this afternoon. Today's session is titled Intellectual Property Essentials, and it will cover the basics of identifying, protecting, translating, and commercializing intellectual property in an academic environment. And this is relevant to people involved in knowledge translation because many of you are developing wonderful evidence-based products for your various KT interventions, and it's helpful for you to know how to protect all that work you've done. So our presenter today, Joanna Preston, is the Associate Director of Health Sciences Technology Management at Tech Edmonton. Joanna joined the University of Alberta's Industry Liaison Office, which was the precursor to Tech Edmonton, in 1999, following a decade working in industrial biotechnology. In her current role at Tech Edmonton, she oversees the provision of intellectual property management and commercialization services to local innovators in the health sciences area. She's a member of the Association of University Technology Managers, the Licensing Executive Society, and is a case study discussion leader for the Canadian Intellectual Property Office. So just before we begin, I'd like to mention that the session today is being recorded. The link will be provided to all the participants along with the presentation slides. It'll be sent out to you after the webinar is over. So the format for today will be approximately 40 minutes of content, followed by some time for questions. And to ask a question, you can type them into the chat screen, and we'll respond to them after the presentation's over. So I really hope you enjoy today's session, and on behalf of the Alberta SPOR Knowledge Translation Platform, I would like to extend a warm welcome to Joanna Preston, and I will now hand the microphone over to her.
Thank you so much. Thanks everyone for joining us today, and I'm glad to hear you're interested in intellectual property. It's very much a passion for me, and I hope I can convey some information that's going to be of value to you in your work. So as Denise mentioned, I think you're welcome to submit questions through the chat window, but I'll try to address them at the end of the presentation just because I'm not entirely sure how long my presentation is, and I want to make sure we get through all of the material. I'm also going to stop sharing my webcam during the presentation just so that I can focus on the slides. I have a number of links throughout the presentation that I'm going to take you to and hopefully show you a little bit about the mechanisms for intellectual property protection and what those look like, and some fun examples that I hope will resonate with all of you. So I represent Tech Edmonton. Tech Edmonton is a joint venture between the University of Alberta and the City of Edmonton. It was formed about 10 years ago now. We're a not-for-profit entity. There's about 60 of us here downtown at the Bay Building. You can see outside and inside. And as was mentioned in my bio, our origins are as the Technology Transfer Office for the University of Alberta. So we started back in the mid-'80s trying to help researchers protect their discoveries and partner with industry to help translate those discoveries into meaningful commercial products for societal benefit. Along the way, we decided that it would be of even greater benefit to start working with the regional community as well and help provide a lot of services to our startup companies to help them establish themselves and grow a technology-based industry in the region. So as a result, we work with many different entrepreneurs and inventors throughout the region, startup companies, technology-based companies only. My group, which is called Technology Management, also works extensively with university researchers and students And I would say that's about 90% of our activities right now, but we do, as technology management, also provide intellectual property analysis services to the regional community. I think we should start our discussions by creating a definition for intellectual property. And I drew this from the World Intellectual Property Office website. So intellectual property is a creation of the mind, an invention, a literary or artistic work, a design, a symbol, and the rights associated with that are intended to strike a balance between the interests of the innovators who create them and the public. So the intellectual property system, and particularly the patenting system, were actually designed to meet two goals, and one is to protect inventors' rights to profit from their discoveries, but also in balance with the ability of the public to benefit by being able to read about the inventions. I'll talk a little bit more about the specifics of patenting, but essentially it involves publishing what you've created rather than holding it as a secret and allowing the greater community to benefit by building on what you've already created, and that helps to advance innovation. There's much debate in the world over whether or not that balance is correct at any given moment, but that was the general intent hundreds of years ago when the intellectual property protection systems were created. There are a number of types of intellectual property protection available to innovators. Patents, you may be somewhat familiar with. They protect the idea behind your novel, inventive product, process, composition of matter, or a process, a method of doing something. I'll talk more about patents in the following slides. Plant breeders' rights are a lesser known form of IP protection that offers some limited protection to creators of new plant rights because they aren't always easy to protect by patents, and there's a lot of commercial value associated with them. I'm not going to spend any time discussing those, but if you contact our office, I can certainly put you in touch with someone who is very familiar with plant breeders' rights. Copyright is all about artistic works and written works, and I will talk in greater detail later in the slides about the copyright protection that is available to creators and also some of the ways to extract value, particularly in a patient-oriented setting. Trademarks, probably very familiar to everybody. You see them all around you, a name or a symbol associated with a brand or a particular product. An example that is quite famous for having emanated from a university is Gatorade, which came from the University of Florida and has generated quite a lot of money for that university. They're fairly uncommon in academia, but they do occur, and I'll talk more about that later. Trade secrets are another form of intellectual property protection, and they are actually an officially recognized form of IP protection. They rely on maintaining complete confidentiality about what you've created, and there are some very stringent requirements on the lengths that you need to go to actually protect your trade secret. Trade secrets are not often found in academia because, of course, our mission is to publish and disseminate and spread information in generally a collaborative atmosphere. So I'm not going to spend much time on trade secrets in this presentation, but again, if you'd like to contact me for further information, you're welcome to do that. So a little bit about patents. So a patent is the right to exclude others from making or selling your innovation. It lasts for 20 years from the date of first filing. Patents are a negative right, which is a little bit tough to grasp initially, but a negative right means you can sue someone else for practicing the rights you've been granted. It doesn't always guarantee your own ability to practice your invention. For example, if there are certain components you've used in your invention, you may have the right to exclude others from practicing the whole invention, but you might need to license rights from someone else who perhaps holds patent rights for a certain component, or even from someone who holds dominating rights in an entire field. An example of that situation would be back in the 80s when the original biotechnology patents were filed by Conan and Boyer for genetic engineering. and they essentially dominated everyone else's ability to exploit cloning technology. Luckily, they were licensed out non-exclusively, and people were able to practice in the field. That doesn't always happen, and in academia, in fact, we have a mandate between all of the university technology transfer offices in North America to ensure that any groundbreaking innovations in a particular field are shared openly to promote innovation and collaboration. Now, patent rights are jurisdictional. They're issued on a country-by-country basis. I'm going to go into details about the patent prosecution process in later slides, but having a patent in one country only gives you the right to exclude others within that particular country. And patent law actually varies slightly from jurisdiction to jurisdiction. I've often found in my experience that it can be very easy to get a patent issued in one country and very difficult in another. In a different field, it might be the opposite. For example, something will issue in Europe and it won't be allowed in the US or vice versa. This is something I'll also talk about a little bit more as we go. So why patent, especially in an academic setting? I really am often asked this question. So universities are non-practicing entities. We don't make or sell any sort of products, but we do come up with a tremendous amount of innovation. Here at the University of Alberta, we see around 100 new technologies every year. And we don't want that benefit to be lost to society. So our role, as we see it, is to take a risk on those very early stage innovations that are even often too early for any industry partner to be interested in, and protect them so that in the coming years, when they're a little bit more mature, or if we're very lucky in that early stage, an industry partner is actually going to feel secure enough about investing in the technology to license our patent and go on to develop it to a marketable state. There's substantial risk involved in developing a product, especially in the pharmaceutical and biotechnology industries. And it takes a long time to get things to market. If you're developing a new diagnostic test, or if you're developing a new drug, a medical device, it's essential to have protection throughout the process so that people continue to invest in the technology until it gets to market. That can take anywhere up to 10 years, even longer in some cases. And oftentimes we're finding the initial patents for a particular technology, medical technology, might be nearing expiration by the time the product gets to market. Those last few years are really when you make all of the money. So when we invest in that early protection, we're doing so with the hope of securing a commercial partner. Patenting is a process. You apply, and your application is judged based on a number of criteria. The first criteria is novelty. It has to have been never published or offered for sale in its entirety in the world. Now, most countries of the world have an absolute novelty requirement, which is, as I said, never before seen in the world. A number of countries, including the US and Canada, actually have a one-year grace period where they allow you to file an application for up to 1 year following your own publication of the invention. So that's novelty. The second criteria is non-obviousness, or an inventive step. It's called different things in different countries. This is the element of ingenuity that is critical to obtain a patent. And it's this 2 + 2 is 5 sort of idea, that the whole is greater than the sum of the parts. This is the step that you spend the majority of time and money in debating with the patent offices. So oftentimes you might have something which looks completely new, but when you look at all of the literature and patent literature that has come before, if it's a logical extension of something, you'll have a challenge in overcoming non-obviousness or inventiveness rejections from the patent office. And we work with our inventors at the university and also with external patent agents from all over the world to help form these arguments and ensure that we can obtain patent protection wherever possible. Usefulness, it might seem obvious that you would want to ensure your innovation is useful before filing a patent application. Otherwise, why would you invest time and money? there have been some very significant cases where patent applications were deemed not useful, particularly back in the 90s when companies were filing SNPs. They were filing patent applications covering gene sequences, and they didn't even know the function yet. And so those applications oftentimes would fail on usefulness. You can't identify how you would actually use this in practice. Another criteria, which is not one of the top 3 criteria for patenting, but is an important element in obtaining successful patent protection, is written description and enablement. When you file a patent application, you have to include enough detail that someone of similar skill in the same art, for example, probably a graduate level researcher, would be able to carry out and create the invention without any experimentation on their part. You can't hold anything back, you can't hold secrets. And in fact, in the US, you are obligated to provide all of the prior art that came before, so people can, the examiners who are actually skilled in the art can evaluate whether or not you've successfully disclosed enough information for someone to recreate your invention. Another important criteria that has been coming to the forefront of the news recently and has surfaced many times in the past, what is actually patentable subject matter? In the US, they used to say it's everything under the sun invented by man. Well, this was back before high technology era. So there were mechanical devices and there were chemical compositions. It wasn't really that tricky to determine whether something had really been invented by man, by a person. I guess that's a gender biased term, but so in recent years, and especially in the US, there has been a lot of debate over what should and shouldn't be patentable. And I'm just going to show you a few different examples. So see if I can send this link to you. I hope this works. Some of you may be familiar with the Harvard mouse, the Onco mouse. This mouse sparked tremendous debate all over the world over the patenting of higher life forms. And the decisions that came about in different countries were actually different. So in the US, they allowed patenting higher life forms. An Onco mouse was patented. DuPont and I think Bristol Myers Squibb actually held the rights to these mice, and they made you sign some pretty onerous agreements if you wanted to use them in your research. In Canada, higher life form patents were actually not granted. They were denied. But in a very tricky sort of a mechanism, the Canadian government allowed the patenting of the cells within those life forms. So there were still some claims, even though it wasn't to the animal or the plant, in some cases, itself. This is also a contentious issue in diagnostic testing. And Myriad Genetics is one of the cases that spent a lot of time bouncing around in the US court system. In the end, it was decided by the Supreme Court that isolated genomic DNA, which was the basis of Myriad's BRCA1 breast cancer test, was not valid. And most of the claims of this patent were actually struck down. It was quite a blow to Myriad, and it changed patent practice in the US substantially, especially in the biopharmaceutical era. Right now, the area that is most contentious is the software area. And you can see in this decision from May of this year, the Federal Circuit said, yes, software patent claims are actually okay. Where in the past few years, people have been telling us, no, you can't patent software anymore. It makes it very, very hard for us to determine what to patent. So it's often a waiting game. You wait for the pendulum of patent practice to swing. The take-home message from all of this is that patent law is not static. It actually evolves based on court decisions. It's constantly changing. And that's where at Tech Edmonton in my group, we spend a lot of time consulting with patent agents, having them come in and occasionally give presentations to researchers as well about the current state of patent practice to ensure that we're capturing value where we can. So as I mentioned before, patenting is a process, and it takes time and money to get to an issued patent. When you start at the initial patent stage, you file something generally called a U.S. provisional application. The U.S. provides for you to file an incomplete application, and you can actually add content to that application over the course of a year. At the 12-month mark, you will generally file something called a patent cooperation treaty application. This allows you to file subsequent applications at national phase at 30 months after the initial application was filed. So the Patent Cooperation Treaty covers 147 countries throughout the world who will all allow you to file this application as a placeholder application in order to file in individual countries later. The application is not actually examined until you've filed it officially with the Patent Office of an individual country. So, you see these multiple arrows here. That's really the starting point for examination and interacting with patent offices in many different countries. We are often asked, how do you decide where to file? You can't afford to file everywhere. You file in the countries where you expect your markets to be. Often people will be filing, of course, in the US, in Europe if they can. Europe is a very expensive region to file applications in. And of course, Canada and Australia, and sometimes Japan, again, very, very expensive. You can estimate that in an English-speaking country, US or Canada, you're going to spend up to $50,000 to get all the way through the process. In a non-English-speaking country, translation costs can actually double the cost of your patent application process. And through all this, you're taking a huge risk because there's no guarantee that a patent will be granted. To help ensure that we are likely to get a successful outcome, my office actually helps with initial patent searching to ensure as best we can that your application will actually meet all of the criteria needed for a successful patent issue. So as we mentioned about the novelty requirement, timing really is everything. It's never too early to start talking about how to protect your intellectual property. And it's not a publish or perish. There's no debate between publishing and patenting. In fact, in practice, we are generally able to do a fairly rapid assessment of the likelihood of obtaining an issued patent. We can never guarantee that that will occur, of course, but at least to get a sense of whether there's a good chance that a particular technology is going to meet the criteria for patentability, and to get an application filed in conjunction with a manuscript review process, for example. Now, even a poster, an abstract, or a thesis can affect your patent rights because they are all considered disclosures which can bar you from that novelty criteria. You have to be also very careful when you have a manuscript coming out or an abstract for a conference, and ensure that it's not being published online before you realize it is. We've run into trouble with that a few times. In short, it's simply never too early to start discussing an innovation with Tech Edmonton or whatever tech transfer or research services office is applicable to your institution. We encourage you to get in touch with us whenever you need to. I was hoping to provide an actual example of a patent, and this is one that I use quite often. I hope you can see it. This is the front page of a US patent, and you can see there's a lot of information here. You can tell it's a patent, an issued patent, because of the number, which is in the millions, and I think right now we're up to in the 10 millions of issued patents. This was issued November 11th, 2014, so that's the issue date. The patent has a title. You can see the applicant, which is often a company, but in this case an individual, and it's the same individual who was the inventor of the patent. The application itself was filed about a year and a half or almost 2 years before the issue date, so it didn't spend that long in the system, which is interesting. And this is for a coffin lid alarm. And of course, how useful is that? If you are inadvertently buried a little bit too soon, you're able to hit essentially this panic button, which sets off an alarm at the top of the coffin above the ground. And it also turns on a little light so you're not too scared. This always makes me laugh. I'm going to take you to the actual Google site for this patent. So you can see the abstract there, and you can also see the claims. The claims are your legal turf, what you can sue another entity for practicing. So in this case, the applicant was successful in getting claims to a portable alarm system for coffins, comprising a shaft, a transmitter, a lamp box, and an extendable lamp box, in fact, and the wires, and a real mechanism within the shaft, because you can actually pull this up and use it for the next coffin when you're very comfortable that everything is okay below ground. An important thing to note with issued patent claims, when you're trying to determine maybe whether you have infringed someone's patent or whether they have infringed your patent, is that all of the elements of this claim have to be present in the other technology in order for infringement to have occurred. So, for example, if someone was to make a coffin lid alarm which was not portable and was stationary and stayed in that coffin all the time, it wouldn't infringe these particular claims. So it's very important to know what you're reading. In general, the fewer requirements within a particular claim that you see, the broader that claim is, the more it will encompass in the legal world. Just a few stats about the U of A. And I'm not sure this is entirely current, but at the last time we checked, my office had assessed over 1,200 inventions from the U of A. We usually see about 100 per year, sometimes more, sometimes a little less. And we had, at the time that this was checked, 650 patents granted. We actually hold an innovation ceremony each year called Innovation Makes Sense, where we reward all of the inventors at the U of A who have received issued U.S. patents in the preceding year. In 2015, the U of A actually made a list of the top 100 global academic institutions achieving issued U.S. patents. We were 87th, which is, I think, fairly respectable in the world. This list was issued by the National Academy of Inventors. Now, patents in themselves are, of course, only the start in the road to commercialization. But the reason we're quite proud of this is because we have a fairly limited budget, as do most tech transfer offices in university settings. And when we achieve an issued patent, it's generally because we've received external support to help with the costs. That support can come either from a commercial partner, a company who has licensed the invention and is helping to fund its development, or from a granting body who may have a commercialization program. For example, the CIHR Foundation and Project Schemes will help support patent costs. The NSERC Idea to Innovation Fund will help, and there may be others. So let's move on to copyright. Copyright is the exclusive legal right to produce or reproduce or publish or perform a literary, artistic, dramatic, or musical work. The creator is usually the owner of copyright. Employers may sometimes own the copyright in works created by employees. For example, the university actually owns my slides that I've created for you today, because that's my job, and I was hired specifically in part to help with education regarding intellectual property. However, the U of A copyright regulations generally vest copyright in the authors. So for researchers, for your copyright in manuscripts or in book chapters that you might write, you are generally considered to be the owner. And I can certainly answer questions regarding that. The copyright regulations are maybe a little tricky to read and interpret, but I'm happy to answer questions offline on that subject. So copyright is automatic. It's any original work that you create is protected without any action on your part. You can mark the work, and you probably should if it's something important that you don't want others to be taking and disseminating without your permission. Copyright lasts for 50 years after the author's death, which is quite a long time. And you can also take steps to register your copyright with the Canadian Intellectual Property Office, and this provides you with a certificate, which can be used as evidence of ownership. So it's just a little bit of extra backup, which can be very important, especially in the commercial realm. Now, one example that I came across that I thought might be relevant to the patient-oriented research realm was an organization called FACET. And FACET, which I will take you to, FACET has a questionnaire for patient well-being. And it's a very specific questionnaire, and I'm not overly familiar, but to me it seems that it is widely used in assessing patient quality of life in trials and other settings. And the organization behind this has taken some very specific steps to protect and ensure the protection, continuing protection of all of their tests. This is sort of the shrink wrap agreement that you're entering into when you use their tests. So you can download them and use them, I think, for free, subject to certain restrictions on your use. So you can't change the wording, and if you do, you need to rename it. You can't call it a FACET test anymore. You can't use the name FACET unless you are adhering specifically to the exact documents that they provide. You can't even translate these documents without authorization. And anything, basically, if they haven't authorized a change to what they've provided under their copyright, you can't use the FACET names. And you're being told that it's considered a violation of copyright protection, which could make you subject to legal action. Now, you also have to ensure that you're marking any of the materials you're using under the FACET name exactly as shown. And we can go to the FACET website for more information, but essentially it's a clear example of how copyright needs to be enforced through marking and warning your users of what they can and can't do. Now, just an aside that in Canada, copyright law protects the moral rights of the creators, and I haven't listed any information specifically here, but moral rights allow you as an author to object to a third party's use of your copyright work on the grounds that you don't approve of its application. So if someone was using a FACET test, for example, and maybe they were putting forward data which was being used for an illicit purpose, or they were putting forth data which was false, the creators of the FACET test could object in Canada on the grounds that their moral rights had been violated, and ensure legal protection for that user to have to stop doing whatever the moral objection pertained to. Something to keep in mind as copyright creators. I'm going to move on to trademarks. And so trademarks are defined as letters, words, logos for product and service names that are protecting the brand of a specific product or a business. And as like with copyright, these are automatic if you wish them to be. You don't have to register. And that's what the little TM symbol represents. This is an unregistered trademark. You can also register them, and they are jurisdictional, so you can register them in individual countries for additional protection. It provides legal backup if you ever have to take action against someone who you believe to be infringing your trademark. Now, registration is valid for 15 years. However, it can be renewed perpetually, so you can keep a brand alive essentially forever. However, you have to police and enforce your trademark. I took a little look around at genericized trademarks, and this is what happens if you fail to police your trademark adequately and people start using it as a common term. And I was really surprised at some of the things I saw. You can see in this list, I mean, I knew aspirin was genericized. I had no idea dry ice was once a trademark, escalator, flip phone, heroin, linoleum, and funnily enough, app. The word app used to be a trademark by Apple, but they've canceled it because it's just so common they can't even pretend to have legal rights to the word app anymore. So there's some pretty funny things that happen in the world of intellectual property protection. There's a lot of rules about what you can and can't register as a trademark. You can't register any proper names, clearly descriptive marks, So footwear, shoes would be ineligible as a trademark. Something which is misdescriptive, it misleads the user as to the purpose of the device or service. Anything that represents a geographical location or the origin, so Edmonton Food Services would not be, for many reasons, would not be a valid trademark. And words or designs that could be confused with a registered trademark or a pending trademark. This is where a lot of lawsuits happen, a lot of infringement cases. So you think that someone else's trademark looks a little bit too much like yours, and you're worried about how to protect your own brand. And words or designs that look very similar to a prohibited mark also are not allowed. You can learn a little bit more about this at this website, Tricky Trademarks, and I have a little bit more to say about that later. So there are lots of reasons that you might want to register a trademark. It's not used a lot in academia. However, it does happen from time to time. And I can think of a couple of examples from the University of Alberta. One is a product called Microbe Cards, which was an educational product which were like trading cards to teach microbiology students about different microbes and the diseases associated with them. E-Triage was an emergency room triage software program. These were kind of cool names that the originators of the products came up with in an academic setting that actually made it all the way to the market. So in order to ensure that you're protecting that trademark, you want to register it with the Copyright Canadian Intellectual Property Office or the U.S. Patent and Trademark Office to show that it's yours, which gives you the exclusive right to use the trademark for 15 years, as I said, and it allows you to bring lawsuits against people who would use a confusingly similar trademark. It helps you flag infringements by others, so you can search the databases to determine if others are registering other marks that might look like yours or sound like yours. And it also helps you license your trademark. Trademark rights are legal rights which can be included in license agreements and add value to technologies that you might want to obtain commercial value from. When I was gathering some information on Facet, I actually encountered quite a number of other organizations using the same name, and so that made me a little bit curious as to what other trademark rights might be associated with that particular name. And I'm just trying to find the link here. I apologize. To lead you through a trademark search. I can do that through the PTO site. So if you're interested in how to do a trademark search, which is fairly easy, you can just go to the USPTO site and search trademarks. And where's my database? Apologies, I'm having a little bit of trouble finding the link. There we go. Okay. Oh, and it tells me there are too many users, so we can't do a trademark search. We can try one on the Canadian Intellectual Property Office. But I won't turn up any results on Facet for the Canadian Intellectual Property Office because I tried it yesterday, unfortunately. But just to walk you through how to do a search, the search page, the basic search is really simple. If we're going to look through all trademarks, we would just type in the word Facet. And, oh, there are a few. Okay, so, but a lot of them appear to be dead. So let's look at this one, which is a registered trademark. And it actually covers the Swedish products associated with furniture rather than any sort of patient-related questionnaires. But these are not confusing products. They would never be confused with each other, so that's why there can be so many different similar names on the market, because nobody would really confuse a patient questionnaire with drug development funding organizations, housing, data management, music, or furniture, which were all the organizations and products I found associated with the name Facet. Trademarks rely on use in commerce. So if you're an academic and you've developed some sort of a cool name for a product or a service you're working on, and you're wondering about when to register it, as soon as you can show that it's going to be used in commerce or it has been used in commerce, you can actually proceed with registration. And clinical trials count as commercial use. That had to be established in a legal case because people were fighting about it. And this comes from the tricky trademarks site that I mentioned earlier. And it's a great source of information on all sorts of trademark-related issues. But you can see that there's extensive debate and a lot of court decisions about what can and can't be done with trademarks in general. Now, as researchers, you're probably going to encounter many sorts of agreements through your career, and a lot of them will actually involve IP rights, whether or not you realize that at first glance. Licenses, definitely, either in licenses to use materials that you've obtained from third parties or out licenses as something that you've developed. And Tech Edmonton helps with those. We are primarily responsible under the U of A signing authority policy for out licenses of materials developed at the U of A. Confidential disclosure or non-disclosure agreements. Those are governing discussions you might want to have with third parties. Maybe you're considering whether to do a trial or enter into a collaborative project. My team can certainly help with those types of agreements. Data sharing and data transfer agreements. Now, those are probably the subject of an entire webinar. My group handles those, the numbers of which have been growing at the university, starting from a dozen or so in 2009 up into the hundreds lately. And these are very potentially complex agreements because of the ownership and provincial health legislation governing the terms of who can and can't use which types of patient data. You can definitely get in touch with me or my team members at the U of A if you're a U of A researcher for help with those types of agreements. Material transfer agreements or clinical sample transfer agreements deal with either research materials or patient-derived materials for collaboration for research purposes. And again, my team can help you with those or route them to the proper office. Research contracts and funding agreements are handled generally by the Research Services Office at the University of Alberta, and we consult with them extensively on any of the intellectual property provisions. There can be intellectual property obligations back to sponsors or industry partners. There can also be financial obligations for intellectual property you might develop using their materials. So it's always good to consult with someone if you find that there are problematic IP provisions in any of your agreements. So if you have questions or concerns about intellectual property rights, whether you want to protect something, whether you're worried about an agreement, please contact your technology transfer office. If you're listening at the U of A, that would be Tech Edmonton, and you can certainly contact me or any of the other health sciences technology management team members listed on our website. And if you're at another institution, it would be your technology transfer or commercialization office or your research services office. You can learn more at the Canadian Intellectual Property Office, and I showed you the website for that earlier. It's fairly easy to navigate, has a lot of useful, easy to understand information. If you are truly interested, you can explore the CIPO case studies, and I'm a discussion leader for these. They are kind of a fun way to get to discuss and contemplate some intellectual property related issues through case studies, considering, what would I do if I was in this situation? How would I deal with my intellectual property? What are the issues to consider? Very interesting way to pursue intellectual property, a little bit more interesting than a lecture. And the USPTO also has very in-depth resources regarding protecting and establishing IP rights. So that's the end of my presentation. I want to thank you all very much, and please feel free to send me questions or comments through the chat window, and I will do my best to answer them, or feel free to connect with me later after the presentation. My contact information is at the bottom. Thank you all.
Okay, thanks very much, Joanna. That was a great presentation. Covered a lot of material in a very engaging way. I think many of us will be thinking about coffin alarms for a while. And, just one question that popped to mind. This will be a very easy one. Obviously, Tech Edmonton is set up to serve the U of A community. Where would folks at the universities of Calgary and Lethbridge go for advice similar to what you would provide to the U of A people?
University of Calgary is a little bit more disparate than we are at the U of A, so oftentimes researchers in medical faculties can contact their faculty because they have a research office in the faculty. They can also, if they're interested in exploring intellectual property protection and commercialization, get in touch with Innovate Calgary. Innovate Calgary is the equivalent to Tech Edmonton at the U of C, but they operate completely independently of the university. And Lethbridge had a technology commercialization office, but I am not entirely sure exactly where that function is housed right now. I believe it is through the Vice President of Research. I can find out if anyone needs a kind of
Okay, thanks very much. For those of you participating, I see some of you have found the chat box. We're getting a couple of thanks for the presentations. Another one, if you have any questions, any of the participants, you can use the same box to put in a question. Just wait a minute.
Thanks everyone for listening.
So, just, okay. Oh. Okay. So again, a reminder that the presentation will be recorded, and we will be archiving the link. And we found that people often enjoy our archived webinars because they can go back to them at their leisure. Some of our recorded webinars are quite widely used. So we have a question from Megan Sebastiansky, which is, what is the most common challenge to researchers in moving from developing a device to implementation and uptake? So.
Yes, that's an important question. And I would say there are many challenges. The first challenge is often in obtaining funding, of course, because there's a lot of discovery stage funding available to researchers. The translation funding is more difficult to obtain. So I would suggest, exploring those translational funding sources that I mentioned earlier, CIHR, project scheme, and NSERC, Idea to Innovation. There's a term called crossing the chasm, and it refers to the very large and difficult to navigate gap between people who are innovation friendly and will adopt something new very early on, and the majority of the market or your audience. And crossing that chasm takes a tremendous effort in some cases. So, having support from third parties to validate, third-party validation for your idea or your device is very important. Regulatory approval in the medical setting, also important and also expensive. So a number of challenges, certainly. But at Tech Edmonton, we have actually a panel of experts that are more focused on company creation and advancement and funding that are devoted much more strongly to actually getting something to market. So if you're considering commercializing a new medical technology through a company, I suggest that you connect with that group. I can provide connections, and they can help you with the more business-oriented aspects of getting something right to the market. I deal more with the early stage stuff. Thank you very much, Megan.
Okay, thanks. I think we may have a couple more questions coming in. Oh, can you just scroll up so I can see that?
Okay, so I have a question. Open government initiatives and institutional repositories, are researchers and institutions more willing to share research findings and publications? I am finding in a lot of the agreements that we do governing collaboration and sharing of data and samples that there are actually requirements that you must deposit your results, genetic analysis or whatever it is, into a repository and share your results. So, and I do know that most of the granting agencies have publication requirements which will ensure publication of results. And Megan asks, what if you work for AHS, can Tech Edmonton still help? In some cases, we collaborate extensively with Alberta Health Services, and we do actually work with jointly appointed innovators quite frequently, and if not, I can connect you to the right channels at Alberta Health Services.
So, okay, I think we may be nearing the end of the questions. So first, I'd like to extend a big thank you to Joanna today for this very thought-provoking and interesting presentation. And thank you as well to all the webinar participants who joined today. For anyone who came in late, I'll just mention once again that the session has been recorded and that you will all be sent the link to view the recorded webinar. And with that email, you will also get a link to sign up for the Alberta SPORE Knowledge Translation Platform newsletter, where you will be notified about upcoming events and activities. So on behalf of the KT platform, I'd like to wish everyone a great afternoon, and I hope you'll join us again next time.